Well, thank you, Mr. Chairman, and members of the committee for letting me testify today on this important issue. I'm here representing the AFL-CIO and thousands of working men and women from the state. As you know, over the years, there's been much learned about the asbestos exposure issue, and after it was finally uncovered that asbestos was so deadly, there's been a lot of awareness training for the workers that are involved in that. But even with that, there's still a great amount of danger in the state. Workers get into many issues around the state, and as they're rehabbing buildings, even this building here in the state capitol is one of those buildings, and they'll get into these situations and run into asbestos, and many times, unfortunately, it's too late because of the way it was installed. As we know, this is a very insidious disease. Workers can go for years without any symptoms, and unfortunately, once they are diagnosed, the victims sometimes have little time to decide what to do. Families are in emotional turmoil, and the last thing they're thinking about is how they're going to sue somebody for their damages. In most cases, they're trying to figure out how they're going to live their life out and survive this deadly disease. In most cases, the results are deadly, of course. This bill, as we see it, is creating more hurdles for these victims, and when these victims are already struggling just to figure out what they're going to do next, them and their family members, I think it's unconscionable that we're creating more hurdles for these workers. Ironically, as these exposure victims' health deteriorates, untold numbers of Wisconsin citizens and communities across the state end up benefiting from mitigation and other work that they have performed over the years. Because of them, many of our schools, places of worship, and office buildings, commercial districts, power plants, paper mills, public structures, and yes, even the building we're in today, are safer places because of these people and the dangerous work that they do. Workers have suffered great losses in the state over the last several years. Not only have they suffered those losses as the workers that have built this great state, but now we're going to hit them with one more time as they die from these diseases. I think at some point, as a former member of the legislature, I think we really need to look ourselves in the mirror and say, enough is enough, and these workers have suffered enough, and it's time to stop the attack on these workers in the state. We believe Wisconsin currently provides a fair, efficient, and just route for the victims filing these claims related to asbestos. We view this bill as creating an unnecessary step designed to delay the process and run off the clock on the most aggrieved asbestos victims. On behalf of the workers, the men and women, the hard-working men and women in the state of Wisconsin, and those afflicted by the exposure-related diseases, I urge the committee to reject this proposal. And on behalf of the AFL, the CIO, and the many hard-working men and women of from Wisconsin, once again, I just urge you to reject this bill. Thank you, and I'll take any questions.
Any questions? I will just respond to a few other people testifying. As I understand it, this bill isn't taking away anybody's rights or delaying anything. It's just forcing, in the past, kind of trial attorneys who don't like to put all the cards on the table to put all the cards on the table. And so I kind of resent that you say that we're, kicking these families when they're down or something. Do you object to the idea that if you are suing a Wisconsin company that is only tangentially involved in causing someone's illness, that the plaintiff be required to, in essence, let the court know what other lawsuits or claims are going on out there? Or does the AFL-CIO object to having everybody know what's going on?
I think, as in my testimony, I think what happens in a lot of cases, these families are in such turmoil that they may not realize that they haven't put all the information forth. So I don't think that in this situation we should be trying to penalize them for something that, once you get into the court case, once you set the emotion aside, and maybe there's a time where you're reminded. I mean, remember, this is the exposure is something that might have happened 20 years ago. I can't remember what I did last week in many cases. So once you get into these cases, I think that we got to make sure that those workers are protected.
Okay, so I'll put it this way. Let's say you got $1 million claim, now they're under the commission. If some company,
If some Wisconsin company is on the hook for $1 million, even though they were only 1% liable, because the plaintiff was not, or the plaintiff's attorney, who certainly in most of these cases would be sophisticated and know better, the plaintiff's attorney is hiding the fact that there are claims being made. So some company that should be on the hook for $10,000, or really under Wisconsin law, maybe on the hook for nothing, they're on the hook for $1 million, that doesn't bother you.
I think that, once this information comes forth, I think that's where you have a judge, or if you have a jury, that's up to them to decide.
But if they don't know, the whole point is, do we lay the cards on the table or not? That doesn't bother you.
Once, at some point, it's going to be brought forth. And so I think in that case, it's going to be up to that jury and those judges to figure out what the right thing is to do.
Okay, thank you. Thanks for coming on over here today, all the way from Janesville. Okay.